Hello everyone. Today, Dr. Rakesh Gupta sir has joined us in throwing some light for the freshly qualified lawyers, chartered accountants, or the law professionals who want to start their career in the litigation, direct tax litigation, income tax litigations. He has a rich amount of experience, and since 90s partner at RRA Tax India, and also the ex-member of the Income Tax Appellate Tribunal, and he was appointed as a member at the very young age of 37 years only. It is our privilege to have Sir around us today to address the queries for all the chartered accountants, lawyers, and the other law professionals who want to start their career in litigation. So, sir, we have it's a Q&A round. I have got some questions wherein I will be asking few questions to you, and obviously, sir, nobody else better than you can answer that because you have got an amount of experience which nobody among us is having. So my first question to you is, what are the sections that one must know in order to work in litigation, income tax litigation in the earlier stage of career?
If somebody wants to go in for litigation, then any particular section, cannot be overemphasized. Yes, of course, those procedural sections under which appeals have to be filed, like in case of the first appeal, section 246, capital A, 248, 249, 250, and the powers of Commissioner 251. They have to be read. Then along with the rules, Rule 46, capital A, which empowers the appellate authority to admit additional evidence. And in case of appeal to the tribunal, then section 253, section 254, these are the sections, which must be known by a chartered accountant or a tax professional. But then when coming to the merit of the additions or the disalliances or the claims which are involved in appeal, then depending upon the under which section that claim, one should know, those sections or the position of law, and not only the sections, but then the sections as understood by the court. So it requires an all-round, but then we cannot say that one must know this first, only then one can enter into litigation. This is a simultaneous process, and therefore one step in this direction, and thereafter, whatever steps are required to be taken, then one has to take accordingly.
Okay. Sir, but according to you, what are some of the basic points that one must keep in mind to, start his, career in litigation? Some basic points.
Basic points is, of course, that you must be thorough in terms of law, because our Income Tax Act has got a large number of sections entitling an assessee to base his claim or assessing officer to make additions, and therefore if you as a litigating counsel now want to demolish the case of the assessing officer, then you must equip yourself, in respect of that law which is applicable in a particular case. So nothing specific except certain general principles like the burden of proof, the law of pleading, the law of evidence. Now all those things must be also known by a litigating counsel.
Okay. So whenever we are briefing our senior, whenever we are giving a brief of a case or or a matter, so what are some of the points therein where we should keep in mind? Because obviously senior is knowing all the basics already. Senior is knowing what is written in the submission. Senior will only give, just need a few, just will give less time to the submission and will get to know the gist of it due to the experience and due to the expertise that he is having due to a wide range of matters that he has handled over his career, just like you, sir. But for young professionals, whenever we are briefing you, whenever we are briefing a senior, so what should be the crucial points we should keep in mind so that we should not waste the seniors' time also, and we should be productive in our time as well?
So first of all, it is very essential to know the facts, and the facts means the facts which are relevant to the issue, and those facts which are admitted in the order, and those facts which are contested by the other party, which you would like them to be established before you make your submissions in law. So crystallization of facts admitted as well as contested, it is very essential. Then to know the evidences in order to prove that contested facts, that's very important. And then what is the position of law, and then whether that law has further been developed by the judge made law or the court's interpreted law. So I mean that briefing has to be such so that the senior should know without much extra efforts from the briefing itself provided by a junior.
Okay. Sure,
I
sir.
always say that any point which is to be contested is like a story. So one part of the story has been told by the assessing officer or the CIT appeal or the tribunal, depending upon against whose order we are contemplating to go in for appeal. And then the SSC side of story, and then to present it in a coherent and consistent manner, so that, and you take, when you brief, you take it as if you are arguing this matter before the appellate authority, as if your senior is an authority who has to adjudicate on the dispute. Sir, here are the facts which are admitted in the assessment order, the facts which have not been accepted by the assessing officer in the assessment order, but we would prove these facts with the help of these pleadings and evidences which we filed, or in case those evidences have not been filed, then we will file petition for admission of additional evidence. These were the reasons because of which these evidences could not be produced. So based upon these admitted facts and the facts which we will establish now on the platform of these facts, then this is the section which is applicable, this is the law which is applicable, this is the interpretations based upon the plain reading of that section, and then here are certain judicial decisions which are on this, and here are the counter or the decisions which will be pressed against us by the opposite party, and how those decisions can be made distinction of. I mean, it should be made in such systematic manner. So in sum and substance, if I have to say, now you feel as if you have to argue this case, before your senior, and your senior has to adjudicate. Now, if that kind of an approach would be, obviously everything will fall in line.
Great, sir. Great. Very, very beautifully put, sir. So, according to you, which are the books which you can, name some of the books so that, a person can keep with himself or herself handy always to grow in the litigation sphere?
Yes. Apart from, of course, the Act and Rules.
Act and Rules,
then,
yes.
The book or the commentary which has helped me a lot, Chaturvedi and Pitsaria.
Yes, yes.
And in Chaturvedi and Pitsaria, when you find a particular proposition, and in that process, when you traverse through the entire sections and the captions under those sections, when they hit your eyes, they somewhere register in your brain. Those captions may not be relevant for the preparation which you are doing for today's case, but once it gets registered in your brain, and whenever next time when those questions come in some other appeal, you immediately remember, oh, it was there, I have read it somewhere in Chaturvedi and Pitsaria. And even Palkiwala's book, though it is a concise book, but I would say, like as we used to read Bihari in Hindi literature, Gagar mein Sagar Bharna. So I mean that book, that book speaks a lot within a far lesser number of pages. So even that can be consulted. Now, insofar as the journals are concerned, now the journals which I had been reading in all these years, of course, income tax reports, but then there is somewhat late reporting in income tax. But then the direct tax reporters published by the CTR, now that is relatively very prompt in reporting, and it consists reporting of not only the tribunal's decisions, but High Court and Supreme Court decisions, and of course all notifications, amendments and all. So I read primarily now these two books. Earlier I used to read even TTJ, I used to read even ITD, I used to read CTR, but all these ITD, TTJ and CTR, now I take it as if they are merged into DTR, and that's my purpose. So I read these two journals, and that covers, I think, most of the judge-made law.
Okay. Sir, if we are drafting a submission, let's say we are drafting a submission for a scrutiny assessment 143.3. We have got the questionnaire from the faceless center. What are the points according to you? If we have been asked, let's say details of the bank accounts or details of the cash transactions or like details of related parties or some invoices and all. So if there are, let's say 10 to 15 questions in a questionnaire, and as a person who has just started his litigation career, just after graduating from law college or just after graduating or just after becoming a qualified CA, as the case may be. So what are his touch points? What are his, how his mind should work while drafting submission to while drafting, replies to those questions, according to you?
Yes. Now, first of all, couple of things which have to be borne in mind and which I always emphasize is that once an assessing officer has asked something, his duty is over. So now this will be for you to ensure that before those assessment proceedings are wrapped up, your reply, your submissions must go. Now you cannot be heard saying, sir, he asked about 4 months back this question. Thereafter, several other questionnaires came, and had this point been so important, then he could have reminded. No, once a thing has been asked, it has been asked. And now you cannot expect the repeat, and then you cannot fall back on this that it has not been repeated. Number one. Number two, I always say that factual evidences, factual pleadings, factual averments relating to any question asked, that must be placed before the assessing officer, because that is the basic grain of law of pleading, that before the court of original jurisdiction you should not be found wanting on facts. So if an assessing officer has asked something, then facts must be pleaded, facts must be proved. Mere pleading may not be enough, pleading with substantiation. So those who have understood this principle was taught to me by my guru when I started practice, and this is the biggest asset with me. And I very vividly remember my guru told me that if you lead yourself whereby you are forced to file a petition for additional evidences before the appellate authority, but then I am not, madam.
Your voice, I just lost your voice.
Okay. So
you were telling that your guru told your Guruji.
My guru told me that if you lead yourself in a situation, or if you lead yourself in such a situation whereby you, because of your lack or negligence, now have been forced to file a petition seeking admission of additional evidence before the appellate authority, then you take it as if you have lost the half of the battle. Therefore, if something has been asked on facts, then you bombard his file with the factual pleadings and evidences, so that at later stage you should not be found wanting that, oh, had I placed even this evidence, then I could have argued. Because any evidence which you do not place at this stage now will constitute additional evidence. And for getting the additional evidence is admitted also, there is a very long drawn process as prescribed under the law. But then I am not saying that the additional evidences, cannot be presented. Of course, they can be presented, but then you will have to make out first of all a case as to why these evidences could not be placed by you in the first place. So your energy, of course, will get drained. So any evidence which you could have filed at the assessment stage and then could have asked as a matter of right from the appellate authority to kindly consider the effect and impact of this evidence. Now your energy is being frittered away on what? Sir, first of all, you kindly take this evidence into account, and this was the reason, because of which I could not file it. But then if an addition has been made without giving you adequate opportunity of hearing, or for that matter, you are prevented by sufficient cause from producing a particular evidence, now of course, in those situations, what can you do? You don't have any other option but to procure those evidence and then file it. But to the extent possible in respect of the matters asked. Now, law of pleading says that your factual pleadings, averments, and evidences must be filed before the court of original jurisdiction.
Okay. Sir, there is a very famous saying in the legal jargon. It's like innocent until proved guilty. So what is your take on this one very widely and popularly used legal jargon?
So this phrase has got no application in the tax proceedings. That phrase has got relevance and relation in the criminal jurisprudence. But of course, that burden of proof, that the burden to prove a particular fact lies on the shoulders of somebody who alleges that fact. Okay, unless of course the negative burden has been placed on the shoulders of either of the party by the law, like in case of section 68. Otherwise, had section 68 not been there, then the burden to prove that this credit appearing in my books of account represents my income would have been on the shoulders of the assessing officer. But since section 68 has created a rule of evidence by placing the burden that the moment there is a credit in my books, then the burden to explain the nature and source is on the shoulders of the person in whose books of account that entry appears. So otherwise, this burden of proof is very important to understand, because after all, if a person on whose shoulders the burden lies, if he fails to discharge, then that fact will be taken to have been, or that fact will be taken to have gone against that person. So that is how the evidences are appreciated. So this is important.
Okay, sir, a lot of times we have seen that many companies go into liquidation. That is where they go to NCLT for liquidation and for the approval of the resolution plan and everything. But there are some ongoing tax litigations, like I will say in case of block assessment, earlier time limit was 6 years, now it has been reduced to 3 years. So there are some recurring issues where for every industry, for every company. So if the assessment has been opened up on one issue, it is bound to open on the same issue for the next assessment year as well, if it is a case of a block assessment. So my question to you is that if a company goes into liquidation, but there are some tax or demand, there is a tax demand and there are ongoing litigations as well. So how do councils and how do tax councils, both from the department side and both from the assessee side, tackle this situation? Because now the tax demand has gone into the liquidator's kitty. Now it is up to the liquidator whether he would be able to invite the bids and sell the company, or approve the resolution plan and pay the tax demands of a department. So in that case, whether the demand gets paid fully or department also has to forego some of the amount after the approval of the resolution plan.
So the moment company has gone into liquidation, then the responsibility to contest that litigation now would shift to liquidators, unless the liquidators have sought permissions from the court that even the outgoing promoters are entitled to appoint, I mean, some independent counsel and subject to the approval from the company law or NCLT or some other court. Now, I have seen as a practical experience now where suppose some resolution plan has been approved or is likely to be approved, and it has gone to I mean a particular group. Therefore, then it becomes in the interest of that group that this litigation is contested effectively. And I have seen in couple of cases where the liquidator has appointed, like our firm, to contest those cases. I mean, in which the coming promoters have got interest, or coming, I mean, that resolution plan in whose favor it has been going now, since they have got interest, so they have got the advocates appointed through the liquidator or through the that IRP or RP. So it so happens, but then if the ultimately resolution plan, I mean, could not be gone through, then obviously the responsibility of the liquidator, whatever demands would come, then of course that demand will partake the character of one of the creditors, and whatever in order of preference, I mean, that has to be paid, that has to take precedence in order to.
And once the resolution plan is approved, the tax department cannot send a notice for the earlier years to the assessor.
That depends upon the terms of resolution. We cannot make it as a blanket proposition. Now, terms of resolutions most of the times say that in respect of the pending demands or the pending litigations, I mean, this is the terms, I mean, this is the condition subject to which it has been approved. So, I mean, much would depend upon the resolution plan.
Resolution plan. Okay. Sir, a last question from my side to you. And with this, thank you so very much for sparing your time. And it really means a lot that, senior people like you, are, interacting with young professionals like us, because we need a lot of guiding light in the form of your words of wisdom, experience, and your practical exposure and everything which comes with that. So my last question to you is for, for actually for search and seizure, we are hearing raids a lot these days on the news, on, we know whether we talk about Uttar Pradesh, Kanpur, Maharashtra, and also somewhere or the other notifications do come at the income tax department website that these amount of some things have been seized and some things have been recovered. So whenever search and seizure happens, what is, if you can, tell us through a story the entire series of events or the sequence of events which happens, that would be a delight to hear from you.
I mean, search is an investigative process. And by undertaking this process, the department collects evidences which have got bearing on the determination of the true tax liability of a person, and seek to lay hands on such unaccounted assets so that those unaccounted assets, once seized, can be utilized for defraying the tax, interest and penalty. So the objective of search is this. And of course, that objective is to send the deterrence message to the fence sitter, that is also there. Now, once search takes place and is concluded, then whatever evidences are collected, those evidences are collected from the places of search and through the post-search investigations from the various sources. Then the appraisal report is prepared with the investigation wing, and then appraisal report is sent to the assessing officer, and assessing officer, based upon the findings of the IO, investigation officer, then after observing the principles of natural justice, confronting the material collected through the investigation, then gives a show cause notice to the taxpayers, solicit and elicit their response and reply, and then takes a quasi judicial view in the assessments of those searched persons and determine the tax liability. And the seized assets then are liable to be appropriated towards the tax liability so determined. So that is how the entire process from, but then search is initiated by the investigation wing based upon some evidence, may not be conclusive evidence, but then that evidence or that material is something which is more than bare suspicion, which is more than bare hunch or rumor. And right, homework is done by the department before the warrant of search is signed by the officials of the tax department, which are of sufficiently higher rank. And on that basis, the warrant is issued, and on that basis, the search is undertaken. So this is एक मोटे तौर पर, I mean, this is that in broad terms I have narrated about the entire process of search and the relevance of the material so collected during search and the assessment of search.
Yes, sir, thank you so very much. And I know you are fond of poetry. And agar jate jate, if you can recite some of your favorite lines for us, that would be great. That will
Okay. Okay. I do compose. I have written more than 100 poems during this period of Corona because I got ample time. But then they are in Hindi.
But
And,
just fine.
Okay.
Hindi is our language. Hindi is our main language.
Yes. And I tell you, Hindi is my, I mean, the first language. English, of course, is a perforce language for me. I have studied in Hindi medium. I have attempted my papers till graduation in Hindi only. I started learning English when I joined chartered accountancy, and therefore I find myself at ease only in Hindi. Many times the people ask me, how do you write Hindi? I say I can write only Hindi because I have been taught that way.
But it does not seem like that. But it does not seem like that, sir. But then there is the experience and expertise comes. A few lines, sir. आपको जो भी पसंद है.
I have written some lines or a very, very long poetry on Kashmir, in which I have narrated, though the time when I wrote that poem, I did not visit Kashmir. Thereafter, I did once visit Kashmir, but then I felt so intensely for Kashmir that केसर की क्यारी को ये क्या हो गया, कौन विषधर यह विष बो गया, केसर की क्यारी को ये क्या हो गया, कौन विषधर यह विष बो गया, मेरे प्यारे देश को ये क्या हो गया, मेरे प्यारे देश को ये क्या हो गया, कल जो चमन आज क्यों खो गया, देवदार चिढ़ के बेतरुख हो गए, देवदार चिढ़ के बेतरुख हो गए, कल तक अपने आज शत्रु हो गए, डल की वो झील आज लाल हो गई, डल की वो झील आज लाल हो गई, आंखों के आंसुओं का सैलाब हो गई. So it's very long poem.
तो बहुत मजा आया सच में. एक्चुअली में बड़ा मजा आया. और मैं पर्सनली, मेरे को भी खुद कश्मीर जगह इतनी पसंद है. और एक्चुअली में इट इज ऑन माय गो टू का जो प्लान और लिस्ट बनाते हैं ना हम सारे, तो कश्मीर हम दादाजी और दादी जी से सुनते हैं कहानियां, और जो और लोग गए हुए हैं, जैसे मतलब, तो पता लगता है कितना ब्यूटीफुल है. अब तो YouTube के थ्रू दिखने को मिल जाता है कि जो भी कश्मीर जाते हैं वीडियो वगैरह बनाते हैं। इतनी सुंदर जगह है, इतनी सुंदर जगह है, और वाकई मतलब सीरियसली बहुत सुंदर जगह है। थैंक यू सो मच सर, एंड आप प्लीज अपना ध्यान रखिए, एंड वंस अगेन बहुत बहुत धन्यवाद और बहुत बहुत शुक्रिया आप अपना समय निकाल के
थैंक यू यीशु,
हमारे साथ आए, एंड थैंक यू सो मच सर। टेक केयर सर।
थैंक यू।
बाय बाय सर।